All right, so we'll just have a little chat this morning. So here's what I want to do. I want to go over the two cases that you all were assigned to read, the Bostock case and the Clark case. And then I'm going to talk a little bit about your final exam project because I want y'all to get started on it next week. And then we will not have class Thursday and we will not have class next week. So I'd like for y'all to use that time to get started on your project and make some good progress on that. And I'm going to talk in depth about that towards the end of the class, so you'll have a better idea of what y'all need to do between now and then. We will have a quiz for this week. It'll be over it'll just be over really what we're talking about today. And then I'm not going to assign a discussion question this week, so y'all don't have to worry about that. And there won't be a discussion question next week either. There will not be a quiz for next week. It'll only be making some progress on your project, and I'm going to give you in writing what I'm expecting you to do by the end of next week, so you'll know exactly what to expect. All right, so let's talk for a second then about, let's start with the Clark versus Champion case. So y'all pull that up if you don't have it up already. And I know that everybody has read, so have a good discussion this morning. So the first thing that I'm noticing about this case is that it's in the United States Court of Appeals for the Fifth Circuit. So does that put us in the state court system or a federal court system? What do you think, Naja? We're in the federal court system. That's exactly right. And the reason we know that is this Fifth Circuit. Remember, the federal court system is divided into district courts. That's your trial courts at the federal level. And then if you appeal from that, it goes to a circuit court of appeals. And they're arranged geographically. I think there's 11 circuits. And then from there, it will go to the Supreme Court. So this is a case then we're not at trial here. That trial's already happened. And one party appealed from the trial. So who is Clark? The plaintiff in this case is Clark. Who is he? What's his story, Ms. Ukachukwu? Who's Clark? He's a security guard. Or no, he trains security guards, right? All right, who does he work for? Champion, right. So the Champion is the defendant in this case. This is an employment discrimination case. So more specifically, what is the federal law that's at issue in this case? Yeah, it's a disability case, right. So what law is it that the court is analyzing here? You said again, Josh? Yeah, the Americans with Disabilities Act. Very good. So that's a federal law, means it would be passed by Congress, and it's a statute. So that is the law that's at issue. So just as a general background, what was Mr. Clark's job? Caleb, what did he generally do? All right, I like the honesty. Who can tell me what Clark's job was? He did. He trained security guards. The Champion provided security, I guess, for companies, and his job was as a trainer. So he's kind of HR/training. All right. And did Mr. Clark have any physical issues that he was dealing with? He was diabetic, right? He was an insulin-dependent type 2 diabetic, and he had been for over a decade. Why does it matter that, or does it matter that he had been a diabetic for over a decade? Right, because one of the ways you can qualify for a disability under the Americans with Disabilities Act is to have a record of having an impairment. And even though he currently did, but he also had a record of one. So remember, the Americans with Disabilities Act allows employees to make accommodations as long as they're reasonable and as long as they can still do the job with or without the accommodation. So he had asked for some accommodations already from his company that were accommodated. What were those? Say that again, Naja. Yeah, he needed a refrigerator, stores insulin. Very good. And they said that sounds reasonable. There was another one they granted. Flexibility for doctor's appointments. That's right. Anybody, does that sound unreasonable to anybody? Anybody have any problem with that? Nope. Seems pretty standard. He made a couple of other requests for accommodation that were turned down. What were those? He wanted to grow a beard, and Champion had a policy against facial hair. So why did they deny that request? But why did Champion say that's not an accommodation that we're going to allow you? I mean, we get why the policy, but he requested it and they said, no, we're not going to allow you to do that. Or did they eventually give in on that one? So what did Des? What kind of evidence did Clark give Champion to support his request for accommodation? For the accommodation for the facial hair, I should be more specific. Yeah, I mean he brought a doctor's note, but the doctor's note didn't say anything about that it was related to diabetes. Good, Yulia, that's right. So they denied that one. What about his request to leave his shirt untucked? Why did he want to do that? Right, he had shoulder surgery and he didn't want to tuck it in. So he brought another doctor's note. And what was the issue, or why did Champion why'd Champion not allow that accommodation? Yeah, once again, he didn't link a disability or a condition to not being able to tuck his shirt in. So you'll notice that he submitted a complaint to Human Resources about that. It was investigated, and they concluded that or actually, I'm sorry. He made, what's interesting is he said after they turned down the facial hair and the dress accommodations, he then said he was being harassed, which could also be a form of discrimination if the harassment was based on the disability. And so he reported that to HR. They did an investigation, and what did Champion find in their own investigation? Did they find that he had been harassed or not? No, they found he was not been harassed. And unsurprisingly, Clark rejected the legitimacy of that investigation. He didn't agree with their findings. So that was sort of some background leading up to the main event, which is the subject of this lawsuit. And what was that? Who can explain to me what went down? Naja, I can tell you read. What happened to Mr. Clark? He was sleeping on the job. That's right. And he got busted for it. And they fired him. So Clark contends that he was fired because of a condition resulting from his disability. And the court says in here, they're very careful to say that he is only alleging that the sleeping violation was related to diabetes. He's not alleging any other disability in this case. So diabetes is the only disability that he's claiming. All right, so what happened at the district court level, at the trial court level? Who won there, Clark or Champion? Champion won. Right, the case says that the district court granted Champion's motion and dismissed all of Clark's claims. So he actually didn't even make it to trial. It's unusual or uncommon. It does happen. It's uncommon for a case to be dismissed without even making it to trial. So then we get into the discussion of the court's decision and the rationale. And you'll notice the courts have developed over time when they're interpreting a statute, they will sometimes develop their own tests Like, okay, for this test, you'll see, like, we're going to talk about harassment. They lay out like 4 things that something has to be to meet harassment. That's not in the statute. Congress didn't set that out, but in courts in evaluating that have set up tests, and then in future cases they apply the same test, and that helps with uniformity of the application of the law, so that we can have more certainty about how a law will be interpreted and applied. So that's how case law kind of augments the statute in this instance. So the court first talks about that you could have direct evidence of discrimination, which I want y'all to think about as like a smoking gun, like an email saying, fire that bastard for having diabetes. I mean, we don't need to do the burden shifting that I talked about last week when we've got direct evidence like that, but it's very rare. Um, if you don't have direct evidence, then you use the indirect evidence, the burden shifting that I talked about last week, where the plaintiff just has to make out a basic case, then the employer has to give a legitimate, non-discriminatory reason, and then it goes back to the plaintiff to prove that that reason was pretext for discrimination. That was a BS reason. And so the court talks about whether or not Clark has direct evidence, because Clark claims that he does. So the court says his basis for direct evidence boils down to the following assertions: that his supervisors knew that he had diabetes and believed it to be a condition that constitutes a disability. Nobody disputes that. That Clark's supervisor stated that Clark may have informed him about previous problems with insulin. Okay. That upon learning that coworkers discovered Clark sleeping, the supervisor responded, "Perfect, let him go." Perfect, let him go were the words that the supervisor used. And then after he woke up, Clark told his supervisor he was going to the hospital, but nobody ever attempted to determine whether there was a medical reason for his conduct. Like, in other words, you guys didn't even stop to wait and see if this was related to my diabetes before you fired me. Incidentally, when did he get fired? Y'all remember where it says he was when he got fired? I think it said he was while he was at the doctor or the hospital, where he got a call saying you're fired for sleeping on the job. All right, so the court says that's what Clark says the direct evidence is. So before they analyze whether or not they think Clark has direct evidence, they look at some precedent, and they talk about prior cases where they did have direct evidence. And then they're going to compare and contrast that. So the first case they talk about from a precedent standpoint is this case called Portis. And I'm at the bottom of the 3rd page in case anybody's following along that closely. Next to last paragraph. So the court says that Clark's evidence of direct discrimination is a far cry from what they've previously found to be direct evidence. What happened in the Portis case? What was the direct evidence in Portis? It's pretty smoking gun. Yeah, but what was the actual evidence? Yeah, they said she would be paid less because she was a woman, and her supervisor told her you wouldn't be worth as much as the men would be to the bank. So that's direct evidence. We don't really need to get into the burden shifting analysis there, because we've got what you would consider to be a smoking gun. All right, so in the Etienne case, which is the next paragraph, what was the direct evidence in that case? Race was the type of case, but what were the actual statements that constituted? Right. Direct comments about not allowing a person of a certain skin color to handle money. That's direct evidence of discrimination. 2 other cases they talk about. The Jones case. What was the direct evidence in the Jones case? It was Go ahead, Susie. Derogatory language, and specifically, the applicant got turned down. The applicant was an African American applicant, and the hiring person, the person responsible for hiring, said, "We're not going to hire a black person unless there are extenuating circumstances. Good old white boys don't want blacks touching their cards in their face." That's direct evidence of discrimination. We've got it coming from the horse's mouth. The last one they talk about is Rodriguez. In the Rodriguez case, the employer admitted that Rodriguez did not get the job because of his allegedly uncontrolled diabetes. So the employer basically admitted that that was the reason the person didn't get the job there. So those are the court cites 4 examples of previous cases where they found direct evidence of discrimination. Now they're going to turn around and compare that to Clark's evidence and see if that's direct evidence. And the difference in the direct evidence and the indirect evidence is really whether or not a person would have to make an inference in order to find discrimination. We'd have to infer that a statement or a sentence or a writing was discriminatory. In other words, it wasn't obvious on its face. It's obvious on its face if somebody tells an employee, "You're less valuable to the bank than men." We don't have to make an inference there. It's obvious. In Clark's case, the strongest argument, the court says, for direct evidence of discrimination is the vice president's statement, quote, "Perfect, let him go," end quote. So do we have to make an inference based on that? Is perfect, let him go in and of itself discriminatory? It's not. It's not. We don't, I mean, you would have to know more. You'd have to infer something from that statement. So the court shoots down Clark's direct evidence argument. The court also in this in this last paragraph on the next page says, to qualify as direct evidence of discrimination, it's then going to set out a test that this court and future courts would use to find direct evidence. So let's kind of look at Clark's perfect let him go evidence under this test. To qualify as direct evidence of discrimination, workplace comments must be, number 1, related to the protected class of persons of which plaintiff is a member. Does perfect let him go have anything to do with the diabetic? No, it doesn't meet that. Was the comment proximate in time to the termination? Was it close to the, yeah, I mean, the comment was, yes, fire him. So that's pretty proximate. Number 3, was it made by an individual with authority over the employment decision at issue? I think McCoy made the statement, perfect, let him go, but it was actually somebody else, I believe, that had the final decision-making ability. Let's see here. Hold on. Anyway, and then the 4th one would be related to the employment decision at issue, and the statement is related to the decision. All right. So, yeah, McCoy was not the ultimate decision maker. So under this test that the court sets out, those 4 things, Clark can't meet all 4. He fails 2 of them. So the court's going to conclude there's no direct evidence of discrimination. The court does say, though, what if when the report came in to the Mr. McCoy that had a picture with it about Clark sleeping? Would that still be related to disability? I mean, to his diabetes in any way? Not directly. It's just him sleeping, right? All right. So they shoot down his claim of direct evidence. So he still, though, is not out of claims. He still can go through the indirect route and say, okay, I'm a person with a disability and I suffered an adverse employment decision. I was fired. And now it's time for the employer to tell us why they said I was fired. And then I'm going to turn around and get to prove that that was discrimination. So let's go through that. The court says Clark, like most plaintiffs, failed to provide direct evidence, but he could still proceed under the burden shifting analysis that we talked about last week. So in order to establish a prima facie case under the burden shifting, Clark would have to show three things: that he has a disability. Any dispute over that? No, he probably has a disability. That he was qualified for the job, and that he was subject to an adverse employment decision. 1 and 3 we don't dispute. He did have a disability. He did have an adverse employment decision. It was getting fired. So the court's then going to look at number 2. Was he qualified for the job? So then they're going to set out another test. And if this is a little bit tedious and exhausting to you, it's because it is. Every time you turn around, the court's got to set out a dadgum test that somebody's got to meet. And it just gets very tedious. So the court says we're going to look and see if he is qualified by showing that, and this is where we get to the meat of it. Number 1, he could perform the essential functions of the job in spite of his disability, or that a reasonable accommodation would have enabled him to perform the essential functions. Essentially, the question is whether he was qualified at the time of his termination. So let me skip to the conclusion real quick. What did this court say about whether or not Clark was qualified? Did they find that he was or that he wasn't? He wasn't. That's right, Yulia. He was not. So let's see why. What does the court say about his ability to do the job and sleeping in general? Yeah, there is nothing in that job that he could do while asleep. I mean, he's got to be awake to perform the essential functions of his job. And he admitted he couldn't do the job at all when he's asleep. Maintaining consciousness, the court says, is a basic element of any job. All right. So then the court then starts to talk about whether or not a reasonable accommodation would have allowed him to perform his job. The accommodation in this case would be what? What would Clark? I mean, he didn't come out and request it directly, but what does he essentially say in the accommodation is that he needed? Say that again. Well, not the refrigerator. I'm talking about related to the sleeping incident. Yeah. I mean, so he said they fired me because I was asleep, but that was related to my disability. I needed an accommodation for that. So essentially he's saying, I need the accommodation of being able to sleep at work. And the court goes through that and they say, there is nothing that he could do while asleep that would allow him to perform. He can't. Remember, you have to be able to perform the job with or without the accommodation. He can't perform the job even with the accommodation here. So Champion is not required to make that accommodation if he still can't do the job. So they shoot down that claim. Then they move on to harassment. And we set out another test. So this is under C, disability-based harassment, on the next to last page. On the second to last paragraph, the court throws out yet another test for deciding whether or not there is a disability-based harassment claim. So they've got 5 things in this test. So we'll kind of go through those one by one. Number 1, that the plaintiff belongs to a protected group. Any dispute that Mr. Clark belongs to a protected group? No. He is diabetic. That could qualify as a disability. Number 2, that he was subject to unwelcome harassment. I mean, he thinks he was. that the harassment complained of was based on disability or disabilities, that the harassment complained of affected a term, condition, privilege of employment, and that the employer knew or should have known of the harassment and failed to take prompt remedial action. So that reminds me of something, a point I want to make at the end of this. So then the court says the disability-based harassment must be pervasive or severe enough to alter the conditions of employment and create an abusive working environment. They would consider the entirety of the evidence, and they would look at the frequency of the conduct, its severity, whether it was physically threatening or humiliating, or a mere offensive utterance, and whether it unreasonably interferes with an employee's work. So I want you to think about it like this. There could be, I just want to make sure it's still recording. There could be a bunch of comments that maybe if they had only been made one time wouldn't be severe or pervasive enough to constitute harassment. But over time, they build up and the cumulative effect is to be harassing. That's possible. It's also possible to have one comment be severe and pervasive enough to affect a term of employment. So, think of, for example, maybe somebody walks by Clark's office every day and sees him kind of droopy and says, "Low energy today, huh?" And that may or may not be a dig at his having low blood sugar, blood sugar, or something like that. But if it gets said to him every single day by multiple employees over a couple of years' time, that might be harassment. Similarly, there could be one comment where somebody could go in Clark's office and say, "You diabetic son of a bitch, you better stop all this or else you're going to regret it. You're going to get hurt." I mean, that might be enough to make somebody fearful for their safety on their job, and that could be harassment. So the court's just saying we're going to look at a lot of different factors. And some of those is the severity, the pervasiveness, that kind of thing. What did they say about, what did the court conclude about Clark's harassment here, whether or not it met the prongs of that test? I mean, the harassment was really based on his disagreement about the dress code and the grooming policy, because they accommodated his other thing. And so the court says, well, you just had a disagreement with your employer. That doesn't necessarily amount to harassment. It could, but it doesn't in this case. You made a complaint or you made a request for accommodation. They denied it. It was investigated. And it just wasn't found to be enough of a connection between what you requested and your disability. So they just decided it was not severe enough to create an abusive working environment. So you add all that up together, and the alleged harassment just wasn't tied to the disability. So they shoot that down. So for all those reasons, the court sides with Champion and upholds the trial court's decision to dismiss Clark's case. So that's the end of it. He did not appeal any further than this United States Court of Appeals. Any questions about Clark? All right, I want to go back and highlight something for you that is important for you as if you're in the managerial role or even if you're an employee. When the court was talking about harassment, it said that Clark was going to have to show that the employer knew or should have known of the harassment and failed to take prompt remedial action. So that puts the burden on the employee to make a complaint. If the employer doesn't know it's going on, then they can't be held liable for it. But notice, it's not just that they knew, it's also that they should have known. So all employers have a responsibility to know what's going on. You know, if somebody walks by and makes a comment in Clark's office that no one else can hear and he doesn't report it, it'd be hard to argue that the employer should have known. If the employer, let's say it's in an office cubicle environment, there's lots of people and everybody hears everything, and the supervisor hears harassment going on but doesn't do anything about it, and Clark never makes a complaint, they still should have known about it because they heard it too. So whenever you get into a harassment situation, you need to pay attention to what they knew or should have known. All right, let's move to the Bostock case. And I want to first start out by saying I misstated the law to you last week when I said that we didn't have a case on trans. When I read this case again in preparation for today, I remembered that this case covers not only sexual orientation, but it also covers transgender employees. So Title VII does now protect both orientation and trans status. So this is a case from 2020, and it, much like the Brown versus Board of Education case, there was more than one case that the Supreme Court consolidated into this opinion because they all were regarding the same thing. And in this case, one of the reasons the Supreme Court took it was because, remember how we talked about in the federal court system, if you appeal from a district court, from your trial court result, you have to go to the circuit that your district lies in. So, for example, California is the Fifth Circuit, or no, is the Texas's Fifth Circuit. So if a case is appealed from the district court in Texas, it will go to the Fifth Circuit. In Georgia, it will go to the 11th Circuit. So it's conceivable that the Fifth Circuit Court of Appeals could decide a case in a different way than the 11th Circuit. And then if we've got these circuits out here having different opinions, then the Supreme Court is more likely to take that case so it can resolve the difference in the different circuits, if that makes sense. So that's what happened here. We had a district court in the Second Circuit that agreed that Title VII does bar discrimination based on orientation, but the 11th Circuit, which is the Bostock case, said it didn't. So then the Supreme Court's got two different circuits out here saying different things. So they took the case, consolidated those appeals, and issued one opinion decision to cover all of it. Who wrote the majority opinion in this case? Which justice? Do y'all remember who wrote this? Which judge? Justice Gorsuch, right. He wrote for the majority. What do y'all remember what the breakdown of justices was? How many voted with the majority and how many voted as a dissenting judge? It was 6-3. So the majority was 6 and the minority was 3 in this case. So Gorsuch wrote the opinion for the majority for the 6 justices that agreed. So what does the court say that the issue is, or what would you say the issue is? Remember the one sentence, what's before the court to decide in Bostock? Whether or not, very good, that's the issue, whether or not someone could fire someone based on orientation or transgender. So we're looking at the law in question is Title VII. And Title VII says that, let's see, I want to make sure I get it right. Title VII prevents discrimination in the workplace on the basis of race, color, national origin, sex, and religion. That's the text of the statute. So the question in this case then, if we take Dez's issue, which he stated correctly, does firing someone for being homosexual or transgender violate or constitute sex discrimination? So one of the ways that the Supreme Court looks at the meaning of a statute is they go back and look at how the public would have understood the law when it was passed. So go back to 1964 when Congress wrote that no employee should be discriminated on the basis of sex. Were they contemplating in 1964 sexual orientation or transgender? Justice Gorsuch says they do. They did. And when we get to the dissenting opinion, the minority, they take a lot of issue with that. So there's disagreement between some of the smartest, judges that we have. So Gorsuch says that we've got to take the plain meaning of sex, and he looks at it this way. If a female employee is attracted to men and if a female employee is attracted to men and a male employee is attracted to men and the male gets fired for it, what is the only difference between the two? Sex, that he was a male and she's a female. So Gorsuch is saying that employer would not have fired the female for the exact thing that they fired the male for. And the only difference is sex. That's how Gorsuch is coming at this argument. He also says that he says you can't discriminate against, let me see, I'm going to say this right. He says that discrimination against sexual orientation is necessarily discrimination based on sex, that you can't have one without the other for the reason we just went over. So that's interesting. The employer argument, Clayton County's argument, was what? Anybody remember what they argued as to why Title VII didn't cover this? Well, they said that, Congress has considered but failed to pass bills that would clarify that Title VII does apply to sexual orientation. So they're like, their argument is, how can you, Supreme Court, say that includes sex when there have been bills introduced in Congress to change the statute to specifically include sexual orientation, and Congress hasn't passed those laws? And who's it up to make laws? Congress. They won't do it. So, court, why are you doing something that is up to Congress to do? The dissenting opinion, if we flip to that for a second, let me hit another employer's argument, that most people in 1964 would not have expected Title VII to apply to orientation and transgender. That is another argument that they made. So let me flip to the dissenting opinion. And the dissenting opinion is very careful to say, we're not saying that LGBTQ plus community members shouldn't be protected from discrimination. We're not saying that. We're just saying that the law that Congress passed in 1964 and the one we're interpreting right now does not protect them. They should be protected, but it's not our job to remake laws. It's Congress's job to make the laws. That's what they're saying. That we don't like having this result, but we feel bound to say that it doesn't cover orientation or transgender because that's not what Congress intended. And if Congress wanted to change it, they've had 60 years now to change it, and they haven't done it. So the dissent goes, they say directly, there is only one word for what the court has done today: legislation. So that's their main argument. In fact, the way that Justice Alito put it is, he says the real question is not whether discrimination because of sexual orientation or gender identity should be outlawed. The question is whether Congress did it in 1964. And Alito says they did not. All right. Any thoughts, comments, questions on that case? All right. Sounds like before y'all take the quiz on Monday, make sure that y'all have read these cases if you hadn't read them already. I'm not going to ask you things as detailed as what is the test for harassment. I mean, I'm not going to ask you the 4 prongs of the test. I just want you to basically be familiar with what happened in the case, what decision was made, and what the rationale was. Okay. Really, I've told you before, I design these things to make sure that you read, because I believe if you read, then you'll learn. So I just want to make sure that you're familiar with what happened in it. So let's move for a second then to your CSR reports. Yes, Des.
Is it possible you can use sexual orientation as harassment, as a form of harassment?
Can you be harassed based on your sexual orientation?
So like if you're in a workplace with straight people, but you hire someone who was straight, but they ended up having a different sexual orientation, that be considered, you fire that person.
What'd you fire them for?
Let's say they're attracted to a person in the workplace.
Okay.
And that person is
Okay.
uncomfortable.
So you're fired. So yes, that's possible, because take orientation out of it for a second. If a male employee is hitting on a female employee and that's making her uncomfortable, then that could be harassment. So same applies to men as it does to women. Now, just being gay, I don't think is a basis for harassment. I'm thinking about, I'm trying to think about some gray area, like what if an employee who was gay had lots of pride paraphernalia, rainbow flags, was very out and representative about their community. I mean, I have a hard time thinking that that would constitute harassment.
But you didn't know this on the basis when they were hired.
You didn't know that when they were hired, but because you can't discriminate against it, it shouldn't matter. I mean, let me put it to you a different way. If you had known that this applicant was gay and you didn't hire him because you thought it might make other people uncomfortable, you've then discriminated against that person in not hiring them based on their orientation. It would have to depend on the conduct of the person. I don't think if somebody is gay and another employee says, well, that's against my religion and I'm opposed to that and it's harassment for me to have to work alongside a person who's gay, I don't think that would fly. The same way that it wouldn't fly for a gay person to say, I shouldn't have to work alongside a straight person. That offends me and that goes against what I believe, and I don't want to do that. Think about yeah. So I think it's possible that you could have that a straight employee could be harassed by a gay employee, but it would have to be conduct, and it would have to be severe and pervasive and meet all of the criteria that we kind of laid out before, not just the fact of what somebody's status is. I can't be harassed by your race. I can't be harassed by the fact that Susie's a woman. I mean, that in and of itself is not harassing. If Susie is my boss and she comes in every day and makes derogatory statements about men, then I might have some harassment. But just because she's a woman and I'm a man isn't going to constitute discrimination. That's a very good question. I like the way you're thinking about it in some nuance. Any others? All right, let's talk about your CSR assignment. So this again, you recall, is your final exam assignment. And it is going to be an analysis of a company's CSR report. All this is going to be in writing, so I don't want you to fret about this. This is just for me to sort of introduce it to you, but all this is going to be in writing. Good morning. You can come on in if you want to. It's totally up to you. I wouldn't want to have to hear this twice, but I mean, you know, you don't hurt my feelings. All right, so your audience is the class. So I want you to think of this as if you're preparing a presentation to give to the class. You should assume that your listener is not familiar with corporate social responsibility or specifically with corporate social responsibility efforts of this particular company. And that's a pretty easy assumption because I don't know that if I say, well, we're going to look at Unilever Corporation and you're going to be like, oh, I know all about their CSR. I mean, tell me something I don't already know. The organization of your report is up to you. I'm going to give you in this written assignment that I will post certain criteria that I want you to use in evaluating the company. But as far as how you organize it, that's totally up to you. Some things I want you to look at when you're going through this, some relevant facts about the company itself. So let's say I was doing Unilever. I don't know why that came into mind, but I can't tell you what they do. I know they make some products, maybe cleaning. I don't know. They probably make 100 products. But so you'll want to give some just basic background about the company. Even something like McDonald's, where we know what McDonald's is, it would be useful to know, you know, McDonald's operates in however many countries, like McDonald's has this many employees, you know, things that would help your listener understand the context of the report. So you'll give some relevant facts, background about the company itself. And then you're going to look at some CSR initiatives that the company is taking. So when we looked at McDonald's, where they were into recycling, they were into responsible sourcing, they were into making the outcomes better for their animals. They were into employee training and education. They did highlight the Ronald McDonald House and some of their charity things. So, you know, you're going to look for some of the major initiatives that the company's doing. It's not going to be hard because the purpose of this report is to put out there what they're doing. So it's not like you're going to have to be, you know, sleuthing with a microscope or something. But that's the main focus is, you know, what do they say they're doing? And what are the features of it? So not just, okay, well, McDonald's says that they're into recycling. Well, tell me what they're doing to be into recycling. What are the programs they're putting in place? What's their philosophy on that? Give us some detail on it. And then one of the most important, if not the most important part of this, is your evaluation of their efforts. What do you think about it? So I want you to think critically about it. You're going to tell me what they're doing, but then I want you to tell me whether or not you think they're doing a good job or a bad job, or they're doing a good job here and a bad job here, or it's not clear to me if they're doing a good or bad job. They haven't really given me enough information on which to base my decision. They say this, but what are they not saying? Remember we talked about in the McDonald's thing, what information do we not have? They said, McDonald's said something about 50% this and 50% that. Well, that's not helpful in terms of absolute numbers. Okay, percentages are great, but that doesn't tell us the whole story. So I want you to evaluate their efforts. It may be that you need to do some additional research on your company. And I don't mean like, this is not some doctoral dissertation. I don't want to worry y'all about that. But let's say that McDonald's talks about their sourcing of food or some input. You might research what is the industry standard for fast food restaurants. There might be something out there that you find that evaluates the fast food industry as a whole on some of these things. So anything that you can find that would support your evaluation, that's fine to bring that in. And I think that'd be good to bring that in. So as you go through this, be thinking, what else might I Google? I mean, again, that's the extent of what I want your research to be. What else might I Google to help me decide whether or not they're doing a good job in this or not? Maybe I go to McDonald's on Bradley Park Drive and see what I can tell from my experience there about what I read in their report, for example. I don't know, I'm just making that up. But see what's out there. You may have a situation like, where, remember when Nike, it's been a while, but they caught a bunch of flack for their stuff being made in sweatshops and other countries where the working conditions were horrible and there were children and that kind of thing. That's a perfect example of going to read something else. You can Google Nike sweatshop and you can find plenty of articles on what went down. And that would be something that you could use to measure what Nike's saying against what you learned about what happened or so on and so forth. So that's a great example of maybe some outside research other than just the report itself. You're going to look at any special issues or areas of concern, like the sweatshop thing, if this is a company that's had some bad press over a certain issue. I want you to look at areas of surprise. What's something that surprised you to learn about the company? And when we talked through McDonald's, there were a lot of surprising things that we learned in there. If there are any other interesting facts or highlights, you're welcome to put that in. Again, the content and the actual content and the organization's up to you. I'm just giving you some broad guidelines. Are there any special challenges that this company faces, like the Nike thing or anything else that pops up? So some things that have not been good in the past. I've been giving this assignment a long time. Like cutting and pasting is a terrible idea. It's obvious when somebody just cuts and pastes. And again, I'm not looking for, I do want you to tell me what the company's doing, but I don't necessarily need you to tell me word for word what they say they're doing. I want to know what you think and how you interpret what they say. So I want it to be your words. That doesn't mean you can't quote McDonald's said they were doing this. That's fine. I just don't want you cutting and pasting like a block of what McDonald's does. McDonald's is a multinational corporate. I mean, don't go to Wikipedia and paste in the background of McDonald's. Also, sometimes people get misled into making this a report on the company overall. And the report is there's too much content on what the company does generally, like as their business. I mean, we do need to know what the company does, but that's not a major part of your report. So be careful not to veer too much into just making it a general report about the company's business itself. Remember, we're focusing on CSR. You can do, you can pick your company. I'm going to give you some websites to go to that kind of aggregate some of these reports. It doesn't have to be the most recent one. You could look at McDonald's from 2018. Maybe somebody's interested in how a company reported in 2021 on how they handled COVID or, I don't know. It doesn't have to be a current one. So you can use your discretion on that. Big companies are going to be easier to find. Any Fortune 500 company, if you go to their website, you will find where they have posted their annual report. And remember, they may call it CSR, they may call it sustainability report, they may call it ESG, environmental, social, governmental things. If you have any question about whether or not you're looking at the right thing, email me the link to it, and I'll click on the link. I'll tell you if you're in the right place. You don't want an article. Some students in the past have taken an article about, let's say that Nike is combating their sweatshop problem, and they've done their report based on this article. I don't want that. I want you to evaluate the company's actual report. It's easier, like I said, to find in a big company, but if you're more interested in a little or smaller company and you can find a report that they put out, that's great. Totally up to you. Some things you could do, like you could even Google Fortune 500 companies and there'll be a list of, I mean, you could go down the list and read through them and be like, oh, well, that's a company that interests me. Maybe that interests me. Some people do like Patagonia. It's pretty easy to, I mean, because one of their corporate missions is sustainability, so theirs is going to be pretty strong. Ones that come up often are Target, Starbucks. I think some people have done Nike, Walmart. It's totally up to you. But if you have a certain interest or something like that, by all means do that. And if you're having trouble finding something, let me know and I'll help you find that. I think what I'm going to ask y'all to do for your assignment for next week when we don't have class is going to be to turn in something that shows me the progress you made on your report. So like, and I'll put this in writing. I haven't written it yet, which is why I'm being a little ambiguous about it. But it'll be something like copy and paste the link to your report in and send that to me, and then I'll ask maybe, what are 5 things that jump out at you just from looking at your report already? What are 3 things that you might need to do some additional research on? What are 10 bullet points that or things will be in your something like that, just to make sure that you've gotten started on it. I thought about just saying send me the link to your report, to the report you're using, but then I fast forwarded to Monday after next week, and then I can see y'all at 10 p.m. being like, "Ooh, I got to find a link and send them a link." So we got a whole week and a half. I want y'all to get further down the road than just picking your company. So I'm going to give you some questions and hopefully get you started on that. I will post all this in writing. You'll have it to read. What's expected of you will be in writing, so that'll be hopefully clear. But if you have any questions on that, please let me know. All right, anybody have anything else? All right, we are done. Y'all will have a good week and next week, and I'll see y'all 2 weeks from today, actually. All right. Yes, ma'am.